everybody, this is Jennifer, and this is my response to Miss Johnson's question in the Hyatt versus Berry Plastics complaint as to why the attorney for Mr. Hyatt included paragraphs 34, 35, 36, 37, 38. So I did my research in Westlaw to try to determine what the required elements to make a prima facie case for religious discrimination and termination would be. So as you can see here, I put required elements in parentheses. I wanted that in the same paragraph as prima facie, and I wanted that to be in the same paragraph as either religious or religion discrimination, and then I wanted termination or terminated or terminate to be in there as well. So that was my search terms I used in the Georgia state and federal courts. So I know that this would only really be looking at the Georgia federal courts for a discrimination case under Title VII. So under the discrimination statutes. So I found this case, which is Kamara versus Epps Air Service, Inc. It is a federal case. It is a reported case, 292 Federal Sup 3rd edition at page 1314, United States District Court in Georgia in the Atlanta Division. So this is a case in which the plaintiff alleges discrimination based upon her religious beliefs or practices. So looking through the case and reading through the case, I was able to find the elements in the case. This was about, this case was based on the plaintiff not wanting her, based on what she, because of her religion, what she was, felt like she could wear to work, and it was a, so in this case, as you can see when I got down here to the bottom, in a religious accommodation case, that under the framework, the plaintiff must first establish a prima facie case by presenting evidence sufficient to prove that she held a sincere, bona fide religious belief, which is what Mr. Hyatt stated in his paragraph 34, that he had a bona fide religious belief, that she informed her employee of the belief in conflict. In paragraph 36 of Mr. Hyatt's complaint, it stated that he communicated his religious belief to his employer, and that she was discharged for failing to comply with the requirement. And so we know that that he was fired from his job, and what then it goes on to say, if the plaintiff establishes the prima facie case, that the defendant must show that they offered the plaintiff a reasonable accommodation. And in this case, in Mr. Hyatt's case, in paragraph 37, I'm sorry, I'm going to go back to this other one, that it was paragraph 38 that Mr. Hyatt said he was, believed he was terminated for his religious belief. And then, as this says, if the plaintiff establishes a prima facie case, the defendant then has to show that it offered a reasonable accommodation to the practices. And in paragraph 37, Mr. Hyatt says the employer could have reasonably accommodated the plaintiff by excusing him from wearing the safety sticker, and that any accommodation of the plaintiff's practices would result in an undue hardship. And Mr. Hyatt goes on to say that there would be no detrimental effect on the employer if he didn't wear this sticker. So these are our elements for a prima facie case or FOSSI case for religious discrimination and termination. And I believe that answers why our plaintiff put paragraphs 34, 35, 36, 37, and 38 in his paragraph, in his complaint, is to show that he had satisfied all that he needed to, and that the employer could, if he argued back, there were accommodations that he could have made to help out Mr. White and not have to fire him. So that's my answer to question 1.